ask 5 major questions. They will be given 30 seconds to answer a question. There will be only 2 attempts for a major question. If answered correctly, you'll be awarded 3 marks for a correct answer. If you're unable to answer correctly, then the question will be passed on to your opponent as bonus for 1 mark only. Subsequent team will get 15 seconds to answer the question for a bonus marks. If you are ready, KNUST and Mountcrest University College, shall we begin? Question 1. And I've never seen the question as easy as this, but perhaps may be difficult to answer. What is an interest in land?
In section 81 of Act 1036 is what gives the holder a right to exercise possession over the land or to gain some element of benefit, and also to exclude other people from possessing the land.
And that is absolutely right. An interest in land is a bundle of rights which may be exercised in or over land by a person. KNUST, mention any 2 interests that may be created in a land. Just 2. Yes.
The allodial title and the usufructuary interest.
Thank you very much. A round of applause for KNUST. You could have the allodial interest. You could have, that's the highest title in land. You could have the common law freehold. You could have the customary freehold. You could have usufructuary interest, as you just mentioned, leasehold interest, and common customary tenancies. Now to Mountcrest University College. This is your major question. The historical foundation of the Ghana legal system may be traced to the Bond of 1844. What was the Bond of 1844 primarily designed to achieve?
Shanties, and also to ensure certain practices that were repugnant, like pioneering, were stopped.
And that's a comprehensive delivery. Thank you very much, Mountcrest University. The British promised protection to the Fanti signatories in the event of aggression. From who? From the Ashantis. Or to form alliance of the coastal states against the Ashanti. So Ashanti has been very powerful if you have not been minded. Yes, to the point that a group had to decide to come together to get protection from them. Now, KNUST from Ashantiland. What? The Supreme Court Ordinance of 1876, Section 14, confirmed the received English law to that existing on which dates? Be very careful.
24 July 1874.
That is correct. Now to Mountcrest University. What is the distinction between offer and, I think predictably, invitation to treat?
So offer, according to entry and NTSC, is any statement or indication by the offeror to be bound by the term that has been expressed. The offer must be specific, it must be exact, it must not leave any room for any ambiguity. An invitation to treat is any statement which does not indicate offer but indicates willingness to initiate offer which is capable of being accepted.
And that's another comprehensive delivery. Thank you very much. KNUST. Now we are in the terrain of making distinctions. And I hope that as they have distinguished themselves, you will also distinct and distinguish yourself as well. What is the main distinction between acceptance and, very naturally, counteroffer?
Okay, so
Yes.
acceptance is the unqualified assent to an offer that is proposed. But counteroffer is where the offeree introduces new terms or tries to contradict the terms as have been proposed by the offeror. So that as have been proposed by the offeror.
Thank you very much. A round of applause for the KNUST Faculty of Law for also distinguishing themselves in making this distinction. Now to Mountcrest University. It does appear that it doesn't matter how much you may come together to seek protection, either from me or from Dean, the Ashantis are in good business today. So, what is the difference between actionable per se and the very obvious actionable on the case?
So in actionable per se, you need not to prove damages. And then in actionable on the case, you need to be proving that there has been damages that has been incurred.
And that makes it as simple as it is and ought to be. KNUST Faculty of Law states the four main aims of the common law of torts.
So the aims are 1, appeasement, 2, deterrence, 3, compensation, and 4, justice.
Thank you very much. Please, a round of applause for him. I love the delivery by both teams so far. Now, to Mountcrest University, what is the distinction? Now we are back to distinctions. What is the distinction between malum in se and malum prohibitum?
You try. You want it? Should I? Okay, malum in se are acts which in their nature are criminal in their nature and they are independent. But in terms of mana prohibita or malum prohibita, malum prohibitum, it means they are offenses that are prohibited by statute.
Thank you very much. And that is also another wonderful delivery. Why do I have a sense? Is it because it's the first round? The questions are easy. Well, I'm not too sure I would have survived in distinguishing 24th of July in 74. All right. So, KNUST, and this is the very final question in the first round. Still distinguishing. What is the distinction between conduct crime and result crime? Conduct crime and result crime.
So conduct crime is a crime that is, it's a crime because the conduct in itself makes it a crime. So the act is criminal. Now with result crime, it is the result that comes out of the crime that makes it criminal.
Thank you very much. Thank you very much. A round of applause for our contestants for distinguishing themselves in the first round. And if you thought it's that simple, I must announce to you that it is not, because there are very key words that they are required to use in their answers, and I get them use the exact words in the definitions that they have given us so far. Ladies and gentlemen, once again, a round of applause for KNUST and Mountcrest. Victoria Entry, Daniel Adewu, and from KNUST, Abuna Frema Chebafo and Frederick Amwesi. Ladies and gentlemen, after the first round between the Mountcrest University College and KNUST Faculty of Laws, here are the results. KNUST 15 and Mountcrest University College 15. A round of applause for them. The Law Challenge. Ladies and gentlemen, we have come to round 2, which is the buzzer round. We'll talk criminal law, contract, torts, Ghana legal system. There are 6 questions. The team pressing the buzzer first will be given the chance to answer the question in 30 seconds. And this is how the sound for Mountcrest sounds like. Thank you. And for KNUST, thank you very much. If you answer correctly, you will be awarded 3 marks. And for every incorrect answer, 1 mark will be deducted. There will be only 1 attempt to the question. Only 1 attempt. Now, ladies and gentlemen, if you are ready, let's begin with the buzzer round. I was first director of legal education in Ghana. I heard it from KNUST first. Who am I?
J.L. Lang.
Professor J.H. Lang, not J.L. Lang. So I'll exercise my discretion to give you 2 out of the 3 marks because of the lack of precision. I was the first native of Ghana to be called to the... You don't even know what I'm talking about. Yes, Mountcrest.
John Mensah Saba.
Thank you very much, John Mensah Saba. I was the first native of Ghana to be called to the bar and also admitted as a barrister in England in 1887. I became the first barrister or advocate to be enrolled to practice in the then Gold Coast. I am John Mensah Saba. Thank you very much, Victoria, for that preemption with precision. Ladies and gentlemen, pay attention. I'm being described by many as a promise or set of promises. Yes.
Contract.
Contracts. And that, in fact, is contracts. I am being described by many as a promise or set of promises which the law will enforce. Others describe me as a set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes a duty. And that is correct. So, ladies and gentlemen, let's continue and please pay attention. I am made to the public at large. KNUST, who am I?
Unilateral offer.
Unilateral offer. I am made to the public at large to... Yes, Mountcrest. General offer. I'm made to the public at large or to a particular person by way of public notice. I can be accepted by one person, usually by the first in time to perform the stipulated conditions. Sometimes I am capable of acceptance by numerous persons. A typical example of me is reward for the return of a lost property or rewards for information leading to arrest and conviction of criminals. I am general offer. Ladies and gentlemen, please pay attention one more time. I am a master. I am held liable for the acts of... Yes, Mountcrest.
Vicarious liability.
And that is correct. Vicarious liability. I am held liable for the acts or thoughts of my servants committed in the course of their employment. I am only liable where the tortfeasor is an employee and the act was committed by employees in the course of their employment. I am vicarious liability. And ladies and gentlemen, in this section, it's about the fastest fingers and luck. A round of applause for our contestants. I made this famous statement, quote, I conceive that land belongs to a vest.
Nana se oforiata.
Say that again.
Nana se oforiata.
Nana se oforiata. How do you do it? I have a statement. I haven't finished even the first line. Ladies and gentlemen, a round of applause once again for Mountcrest University. Daniel Adeu. I made this famous statement. I conceive that land belongs to a vast family of whom many are dead. A few are living and countless hosts are still unborn. I am Nana Se Ofori Ata. A round of applause once again for our contestants, the KNUST and Mountcrest University faculties of law. At the end of the second round, which is the buzzer round, KNUST, they had a score of 1. Mountcrest University, 15. A round of applause for our contestants. The Lord Challenge. I have seen things within this contest before, that those who were down overtook with the speed of light. So for those of you who feel a bit dampened, your spirits, please don't, until the final whistle. The third round is the round known as the profound quotes and personality identification. So each team will be giving 3 major quotations and will be asked to identify the personality the quote is attributed to, and or in which case. Each team will be giving 30 seconds to answer a question. Please, this is important. 30 seconds. If you answer correctly, 10 marks will be awarded. 5 marks for a partial answer. There will be only 2 attempts for each question. There's no negative scoring for incorrect answer. Each team will also be given an opportunity to identify 1 personality within the legal fraternity. This is a non-transferable round. Ladies and gentlemen, if you are ready, Mountcrest University and KNUST faculties of law. The Constitution is the supreme law of the land. KNUST. All persons must look at it and adjust their actions accordingly. This statement is credited to who? In which case? 30 seconds.
NPP versus Attorney General.
Incorrect. One more opportunity.
Ghana Bar Association versus the Attorney General.
That's incorrect. You've exhausted your attempts. The bell has not gone on you yet. But we still must turn to Mountcrest University College Faculty of Law to see whether Victoria or Daniel will give us a glimpse. Please say that again.
Pagain Yabwa versus UH Mensa.
That is correct. Are you not excited for her? Thank you. In this round, when I transfer to you, I just want to test your power, but not to get your marks. Thank you. Now, to Mountcrest University, here's your question. The president is the fount of honor. The Constitution seeks to maintain that awe, dignity, and majesty that surrounds the office and insulate it as far as possible from the humdrums of legal proceedings. That's why he is not subject or liable to criminal or civil proceedings whilst he is president. That was an addition to the quotation. This statement was made in the case of
Salah versus Attorney General.
and that is correct. Salah versus Attorney General. Correct. Victoria for the full marks. KNUST Faculty of Law. This is a long one. And I don't like the long ones because they are difficult. It has never been a principle of the customary laws of Ghana that the self-acquired properties, whether acquired before or after his ascension to the stool, of a stool occupant, become merged into stool properties by the mere reason either of the owner of such properties occupying a stool or of the absence of a pre-installment declaration or earmarking of such properties. It is a matter of evidence at every stage in the history of a given property whether that property is self-acquired or family owned. Who is speaking? In which case? 30 seconds, 2 attempts. Unfortunate, you have been bailed out. Who came to mind and which case came to mind?
Akufo-Addo in what versus AJ?
I didn't ask you. And she's correct. Now, Mountcrest University College. Here is your quotation. All the implied terms are subject to the express terms of the agreement, and within limits, they may therefore be excluded or modified if apt words are used, provided the party relying on such exempting clause carries out his contract in its essential respects. In other words, he does not commit a breach fundamental to the terms of the contract. Who is speaking and in which case?
Kosa in Bartholomew and Co. versus Edigenfi.
A round of applause for Victoria once again. KNUST Faculty of Law. Here is your statement. A successful plea of mistake wipes out any view of consensus and destroys the foundation of an agreement. Who is speaking and in which case?
The case is Attorney General versus Faro Atlantic by Francois JSC.
Francois JSC is absolutely correct. But in which matter is he speaking? Yes. Faro Atlantic may have made a reference. Victoria, is that correct?
Adai versus Pioneer Tobacco Company Limited.
And that is correct. But because it's a non-transferable round, they're entitled to their half mark of 5. Now to the very final question. Daniel, have you ceded to Victoria on this round? Okay. My lords, in my view, a claim for damages for breach of contract will entitle the plaintiff to nominal damages only, unless the plaintiff gives particulars of special damages. Who is speaking and in which case?
Set 2 in AJ versus Faro Atlantic.
Faro Atlantic is here, and that is absolutely correct. Dr. Seth Chum, JSC, in Attorney General versus Faro Atlantic Company Limited, 2005-2006. Ladies and gentlemen, a round of applause once again for our contestants, KNUST Faculty of Law and Mountcrest University College Faculty of Law. Now, it is time to show us that you know the personalities within the legal fraternity. Mountcrest University College, who is on your screen? That is Justice Gabriel Scott Huaman of the Supreme Court of Ghana. Now to your major task, KNUST. Please identify the image on your screen. KNUST.
Gertrude Tokonu.
Justice Gertrude Tokonu of the Supreme Court of Ghana. Thank you very much. And on that note, a round of applause for our contestants. The Law Challenge. And we have come to the end of this third round of profound quotes and identification of a personality within the legal fraternity. And at the end of this round, KNUST made 15 points, as against Mountcrest University's 30 points. It's a round of applause for them. Ladies and gentlemen, we have come to the very final round of the contest between Kwame Nkrumah University of Science and Technology Faculty of Law and Mountcrest University College Faculty of Law. And this is the round of speed. And the speed can make you king or queen. Now this is the rapid fire round. All you tell me is a statement I made is true or false. The 1992 Constitution provides that the Supreme Court, when reviewing its decisions, shall be constituted by not less than 5 justices of the court. True or false?
False.
That is false. The Court of Appeal, like the Supreme Court, is not bound to follow its own previous decisions. False. True or false?
False.
That's false. To qualify as a contractual offer, the statement or conduct must have been made with the intention that it would become binding as soon as it was accepted.
True.
That is false. It's true, correct. A unilateral offer made by way of advertisement would qualify as a contractual offer.
True.
That is true too. The burden of providing or proving negligence is always on the plaintiff.
False.
That's true. The thin skull rule is under causation in negligence.
False.
That is true. Civil wrongs are actions or omissions that are unacceptable but are personal in their effect rather than notionally affecting the whole society and for which society might not consider it necessary to punish the offender. That's true. It is criminal for a man to fail to provide the necessaries of health and life to his neighbor's abandoned children, even if harm should result.
False.
That's false. In Ghana, the criminal law seeks to persecute offenders, not to prosecute them.
False.
Obviously false. Where a person is charged with an offense before the High Court or a regional tribunal against a state or any state agency, he may offer compensation or make restitution and reparation for the loss, harm, or damage caused.
False.
True or false?
False.
And that is true. Now the KNUST Faculty of Law. Here we go. The state has an interest in ensuring the peace, growth, strength, development, and progress of the society, and will therefore from time to time identify actions or omissions that could impede the rationalization of these aspirations, and then legislate to criminalize them.
False.
True. It is criminal for a man to fail to provide the necessaries of health and life to his own children.
True.
That is true. A bill for the amendment of an entrenched provision of the 1992 Constitution shall not be passed by Parliament unless a referendum is held on the bill and 40% of persons entitled to vote voted and at least 75% voted in favor of passing the bill.
True.
Correct. The President may, acting in consultation with the Prison Council, grant to a person convicted of an offense a pardon either free or subject to lawful conditions.
True.
Please listen to that question again. The President may, acting in consultation with the Prison Council, grant a person convicted of an offense a pardon either free or subject to lawful conditions. You said true. The pure theory of law, or the basic norm called GRU norm, was put forward by John Austin.
False.
That's false. Where the auction sale is without reserve price, the vendor or his agent can bid only once openly at the beginning of the auction before any other bid is made.
True.
False. In principle, a performance cannot properly be said to constitute acceptance of an offer if it was made in ignorance of the offer.
True.
That's true. A driver who has a right of way does not owe a duty of care to other road users.
False.
False. Res ipsa loquitur need not be specifically pleaded for a party to rely on it.
True.
True. In Ghana, it is not a crime to engage in an adulterous relationship or to engage in fornication.
True. True.
And that is true. But why shouldn't that be false? A round of applause for our contestants. Ladies and gentlemen, when I say the Lord challenge, what will be your response? At the end of the very final round in this contest between Mountcrest University College and KNUST faculties of law, Here are the marks. KNUST made 24 points as against Mountcrest University College 21 marks. The cumulative or final score, KNUST 55 as against Mountcrest 81. In the premises, ladies and gentlemen, Mountcrest University College Faculty of Law have emerged victorious in this very first contest. So a round of applause to Victoria Entry and Daniel Adewu. And thank you for a good job done also Abena Frema Cheba and Frederick Amwesi. A round of applause for our contestants once again.